We are now recording. Welcome, everyone, to episode 36 of the FCPA Compliance and Ethics Report. It's my distinct pleasure to have back as my guest the FCPA Professor, Mike Kohler. He is going to visit with us on several different issues, but our topics generally relate to what's on his mind. One of the things that he communicated to us in February was that in the month of January, he had his greatest number of hits ever on the FCPA Professor blog site. Obviously, it was the start of the year, and he had some year-end wrap-ups. He looked at some numbers, but he gave us a lot of information and a lot of opinions about where he thinks enforcement has gone, where it may be going, and frankly, maybe even went off the rails in a few places. So with that sort of broad introduction, welcome, Mike. It's always a pleasure to have you back, and really what I wanted to visit with you about are what's on your mind today and what's on your mind in sort of the middle of Q1 2014 in the FCPA world.
Yeah, thank you, Tom, for having me back. It's always a pleasure to chat with you regarding a topic of mutual interest, obviously. January was my most read month, I guess, in the 5 years I've been running FCPA Professor. Very grateful for the response that my website has received. It's amazing to really just have an internet connection and be able to connect with people all over the world, and to add your ideas into the marketplace of ideas is a very enjoyable experience. January tends to be my most favorite month, I guess you could say, just from an FCPA enforcement standpoint, because I'm able to crunch a whole bunch of numbers concerning the past year. So many of my posts in January were indeed crunching the numbers and providing statistical, empirical data that I hope is of value to a lot of people who are not just seeking opinions about the FCPA, but actual hard data. So posts were devoted to SEC enforcement from 2012, separate posts for DOJ enforcement, separate post for whether enforcement was up or down, separate post for individual enforcement actions, so on and so forth. And what the numbers show is that there's a lot of discussion around the FCPA that I think, quite frankly, in some respects is misguided. And furthermore, that the numbers sort of reveal once again, as we've seen in prior years, that DOJ and SEC rhetoric is a lot of times undermined by the numbers.
And did the numbers communicate to you that enforcement was up or down? Or one of the things that I think we're both a little frustrated with is not so much the numbers, but the arbitrariness of when these cases are settled, because it takes so long, certainly from an incident, but even after it's detected and an investigation begins. And certainly I won't speak for you, but I've not been able to discern a pattern of how long it might take or when something would lead to a settlement.
You're absolutely right. I think the first point is yearly statistics need to be received with a grain of salt, because at the end of the day, does it truly matter in terms of general trends, whether, for instance, the Alcoa enforcement action that happened on roughly January 5th of this year is going to be put into 2014 versus if it happened 7 days earlier and be put into 2013? No. But taking yearly FCPA statistics for what they are, and that is a snapshot of enforcement activity over a 365-day calendar period, the enforcement activity was down. Now, I believe that the most accurate and reliable way to keep FCPA statistics is by using the CORE approach. The CORE approach analyzes unique instances of FCPA scrutiny based upon the facts alleged, not whether there is a DOJ enforcement action as well as a SEC enforcement action, not whether that enforcement action is split between the parent company and the relevant subsidiary. And, the Department of Justice has endorsed this core approach to FCPA statistics. So if you look at it from a core standpoint, 2013 was one of the slowest, I guess you could say, years of FCPA enforcement in really the last 5 or 6 years. Conversely, if settlement amounts are your thing, which they seem to make headlines, but in terms of settlement amounts, we saw more in settlement amounts this year than we saw perhaps in 2012. But I don't know that just looking at settlement amounts is a meaningful way of looking at this.
Perhaps the only thing I would say about settlement amounts is it probably states the obvious to us, which is settlement costs seem to be increasing. Certainly they've increased from 5 years ago. I'm not sure if they've significantly increased from 2012 to 2013 or even increased because we saw some lower ones. But that seems to be, like I said, a fairly self-obvious observation, one even I can make.
As one of the law firm client alerts recently said, the market value for resolving an FCPA enforcement action seems to be going up. And I've written about that issue as well. I mean, on one level, if FCPA enforcement actions are going up just because, well, that's problematic, right? If that's what the conduct at issue warrants, that's fine. But, just by way of an interesting analogy, a mere 6 years ago, the largest FCPA enforcement action of all time was approximately $45 million. In 2013, the relatively minor garden variety type of FCPA case, an enforcement action against Diebold, where literally Chinese foreign officials were, visiting the Grand Canyon in Hollywood, that settled for $46 million. And if you match up these two enforcement actions, you see that per the DOJ and SEC's own allegations, this was much more egregious, the Baker Hughes one. So I take your point and agree with it that one has to ask, are FCPA enforcement settlement amounts going up just because?
I have heard the figure of 2 to 6 times the end fine or penalty as companies' investigative costs, remediation costs, and other costs for an FCPA investigation. Have you heard any even anecdotal figures which would lead you to speculate on some multiplier of what the internal cost might be?
I'm not sure I understand what your question, though. Can you repeat it?
Sure. I've heard a couple of CCOs who've gone through an enforcement action have come out on the other side with a deferred prosecution agreement or other resolution, give the figure of whatever their final number was. It was 2 to 6 times that in their cost for the investigation, remediation, and other related costs leading up to the final resolution. Have you heard any anecdotal numbers along those lines?
Well, I've heard anecdotal numbers, and I completely agree with you. I frequently talk about the 3 buckets of FCPA financial exposure. Bucket number 1 is pre-enforcement action, professional fees and expenses. Bucket number 2 is what you hear and read about on enforcement action day, in other words, the settlement amount. And bucket number 3 is the post-enforcement action professional fees and expenses. And I would completely agree that in nearly every FCPA enforcement action, bucket number 1 is by far, whether the multiple is 2, 5, 7, or even 10, the largest bucket. Now, empirically analyzing that and coming up with an average figure is next to impossible for the following reason. All companies have different disclosure practices. So while Walmart and Avon and some other companies do disclose their pre-enforcement action professional fees and expenses, other companies don't. So you're starting with a universe where there's not a consistent disclosure practice there. But yes, anecdotally, whether you look at Walmart or Avon, their bucket number 1 expenses, their pre-enforcement action professional fees and expenses are far going to exceed anything the Department of Justice or SEC is going to require of them in a settlement amount. Now, you can look at this in one of 2 ways. You can look at it in terms of bucket number one is the most expensive, and you can accept it as a fact, or you can look at it and ask, well, has FCPA scrutiny turned into a boondoggle for many people in FCPA Inc., which one encouraging thing I've seen over the last 3-4 months or so is that some FCPA practitioners raising this issue, including Homer Moyer, who is a very experienced, and I've called him the dean of the FCPA bar before, raising this question, does this really need to be that expensive?
Right. What about bucket number three? Any anecdotal costs there other than what we found out about the cost of some of the monitorships?
Yeah, again, it's all anecdotal because some companies who have monitors imposed upon them, they are disclosing on a quarterly or yearly basis some of the monitor expenses, but other companies aren't disclosing that. Companies that are disclosing it, it is the smallest of the three bucket, which sort of makes sense, right? But it is still a meaningful component of the overall financial picture for companies undergoing FCPA scrutiny. Whether that number is $3 to $5 million per year, or in the case of larger companies, $10 to $15 million, it's a significant cost in many respects that investors who are paying attention to this are concerned about.
What were some of the other top posts that you had in January, or at least posts that garnered the most number of hits?
Well, I've been frequently calling out, or I should more accurately say, matching numbers to statements and thus imposing some accountability on the DOJ and SEC when it comes to their individual enforcement action numbers. We hear time and time again that enforcement against individuals is a cornerstone of FCPA enforcement. We hear time and time again that in order to achieve maximum deterrence, the Department of Justice and the SEC need to hold individuals accountable. And while 2013 did see a cluster of cases, the fact remains that approximately 73% of DOJ corporate enforcement actions over the last 5 years have not resulted in any FCPA enforcement actions against individuals. And even more surprising, and I say surprising given that the SEC is a civil law enforcement agency and thus has a lower burden of proof, 82% of SEC corporate FCPA enforcement actions over the last 5 years have not resulted in any enforcement actions against individuals. But even that number, as I've frequently said, including during my testimony before the Senate in 2010, that number can be looked at two ways as well. The first way, and the typical way I think it's looked at, is but why was nobody charged question. I think the better way to look at that is to ask yourself, do DOJ and SEC corporate enforcement actions, particularly those resolved via an MPA or a DPA, truly represent provable instances of FCPA violations? And I think the answer is no. And a relevant data point on that is that when the DOJ resolves a corporate enforcement action solely with an MPA or DPA, there's only about a 9% chance that an individual from that company will be charged. One final interesting data point, too, and I've been thinking about this for a long time and really can't come up with a good answer other than that publicly traded companies are more risk-averse than privately held companies. But a privately held company, a corporate enforcement action against a privately held company, there is a 3 times greater chance that an enforcement action against that type of company will result in individual charges. That's pretty wide gap, I think.
Well, I guess if I looked at that, I would probably opine that You're absolutely correct. I think that public companies are more risk averse, but the couple of matters that have actually gone to trial involving companies were smaller companies where the individuals were really the company. They were private companies, and so I guess that part really doesn't surprise me as much. But there's another question that I wanted to pose to you. I don't know if you might have any insight into it. We had two instances in 2013 where 4 individuals were charged with FCPA violations. One instance with the French company Alstom, the second instance in the DAP partners, where 3 DAP partners and 1 Venezuelan bank official were charged. But those were cases where the individuals were charged before any corporate enforcement actions were brought. Any speculation, insight, or other into why that situation would occur? We just typically don't see that.
Well, we have seen it before. It's not that uncommon. I do agree that the more common approach is after, but it's not unprecedented for individuals to go first. For instance, individuals associated with Alcatel-Lucent, that happened way before the corporate enforcement action. I think when it comes to some of these individuals, there's kind of a domino effect such that if a foreign national happens to make his or her way into the United States territory, that person is going to be arrested when they come on U.S. soil. So that is the triggering effect of that enforcement action. And then once one person is arrested, you sort of have to go with the whole thing. That's my observation, but it's not unprecedented for, in many cases, individuals to be charged before a corporate enforcement action. And all this is wound up into these statistics. So these statistics I just mentioned a few moments ago take into account both of those variables.
I'd like to change the subject a fair amount here and move to recently, I believe last week, you announced that you had partnered with a company called M-Train to release a FCPA training video course. And I'd like to visit with you a little bit about that. I had you graciously allowed me the opportunity to view it, and I found it a very, very interesting presentation for several reasons, and I'd sort of like to walk through that with you. But if I could start, how did all this come about? How did we get the FCPA Professor actually moving into the commercial world? It's great.
Yeah, just call me part of FCPA Inc.
Exactly.
No, I'm very excited about this, and it's really a perfect marriage in the sense that it matches my knowledge and learning techniques with technology, which I clearly don't have, as evidenced through our exchange here via Skype. It's really exciting. I do truly believe that this training course is going to elevate the learning experience for business organizations and others in the compliance community who are looking for a new, a fresh, and interactive, a fun, a comprehensive learning tool that they can share with their employees no matter where in the world they're located.
As much as I found it very informative and useful, the thing that really struck me about it is you used 3 or 4 different learning techniques in one 1-hour video. So I'd really like to focus on that, and I say that for another reason. Early on when I began my blog posting career, I wrote about training, and you shared with me some of the thoughts you had on the different types of training and why it was important to do live training or to have interactive training, to give people the specific information, i.e. your background authority on certain things. And you really were able to incorporate all of those techniques into really a 1-hour video. So how did that come about? Did you work with M-Train, or what was the genesis of that?
Yeah, this is where their technology and their expertise certainly comes into play here. I've now been teaching for 5 years, and gone are the days when you just stand up and convey substantive information to people. One of the many things I've learned by being a professor for 5 years now is many people have different learning styles. You need to keep it fresh. You need to engage learners. Now, whether that's through visual devices and visual stimulation, or in this training course, having the learner mouse over certain icons that will then pop up substantive information for them, having them answer questions in the context of what they're learning, assessing their learning throughout the course, not just putting up PowerPoint slides, but having actors portraying real-world scenes where the learner is required to issue spot the issue. Now, you can't capture in a course of this nature every possible, conceivable variable that is out there. And of course, live training is still the best type of training. But for a multinational company with thousands of employees all over the world, that's just simply not a practical reality. So the interest in this course, during week 2, has been very strong, and I truly do believe that this is going to elevate the FCPA learning experience and be a valuable asset for a lot of companies who are looking for new, fresh, innovative, and memorable ways to arm their employees with the substantive knowledge, not to be FCPA experts, but to be able to spot risk in their unique job functions.
If somebody wanted to check it out, how would they do so?
Well, there's a number of ways. On my FCPA Professor website, you can just look back in the prior 2 weeks of post and see stuff there. But you'll see at the top of my website, I have a training tab, and you can go on that tab and you can view a free demo version of the course. And if you're interested in more, you can always contact me, FCPA Professor at gmail.com.
And I think the website is mtrain, spelled EMTRAIN.com, if I remember that correctly.
Yeah, that's correct. mtrain is sort of a condensed version of employee training, so that's where the name of that company comes from. And this is a company that is not new to this space. They have many valuable and useful training courses out there already, and this was their entry into the anti-corruption space, and I'm very happy to be partnering with them on that.
Well, from sitting here, from my perspective, it's good to see you out commercializing some of the skills you've developed, and I think it's a very good addition to FCPA Inc. And a good addition, actually, to the delivery of services and products that help companies do compliance. So for all of those reasons, I congratulate you. I encourage people to take a look at it either on your website or go to the mtrain website. I think it can be a very useful tool for your compliance program going forward. We're at the end of our time here, and say I've greatly appreciated it. For those of you who might be interested in a little teaser, our next episode, the professor and I are going to discuss one of our favorite topics to debate. So I hope that you'll consider listening to us next time. With that, I'm going to sign off. This is the FCPA Compliance and Ethics Report, and I'm Tom Fox. Thank you very much.
Thanks, Tom.